Someone answer for me. How many depositions have actually taken place since April?
The judge is so mad. Look at Diller. One? The answer is going to be one depo? Oh, no. We are focusing today on 2 hearings that are taking place regarding discovery in the wrongful death litigation. Now, we know that everything in the Karen Read litigations have tentacles. We've got the federal Karen Read sues everybody case. We've got the state level, the O'Keefe's sue Karen Read, and the Barrs case. We now have the McCabe's, Alberts, and Higgins suing Karen Read and Aidan Carney. We also have the floating notion that Karen Read is going to sue Canton, the city, not just the individuals, and probably also law enforcement entities, but they were waiting to get more discovery that was happening in the criminal cases that are still ongoing, where they were trying to get discovery from Michael Proctor's cell phone, which they're going to be allowed to use. And the ripple effect of the fuckery continues to crash against the shore. And the Karen Read civil wrongful death case, where she is a defendant with the O'Keefe's, continues to move incredibly slowly. The last time we were in court, the judge was like, you guys, if you're having discovery issues, you need to tell me. Bring it to my attention. We need to get this moving. We have a lot of lawyers, a lot of parties, a lot of depositions. The first hearing we are looking at comes from May 5th. That hearing was on calendar to deal with Canton. Remember, there was motions to compel pending. This is the hearing regarding the motions to compel. Then we are going to take a look at the discovery hearing that was then set on May 7th.
Let me ask the town's attorney. Your opposition appears to be characterized based on 3 reasons: scope, relevance, and an ongoing internal investigation. Would you agree with that?
Yeah, sure.
Okay, so let's.
The ongoing IA investigation is regarding Good. And Good's IA investigation is regarding his chats, texts, communications with Proctor. Yeah, with Proctor.
Let's talk about the last one first, the internal investigation. And Ms. Reed's attorneys cite to the Boston Police Superior Officer's case and a couple other cases. So why are those cases not on point?
Well, Your Honor, I believe those cases mainly spoke to whether or not information was discoverable. I think, and we're not saying that ultimately these materials wouldn't be disclosable, and frankly, we think most of them would be a public record. We're just asserting that as a practical matter, we're concerned about the impact that producing these records could have in the pendency of an investigation, whether or not the key subject of any argument or case or controversy in the instant action. While we're still gathering witnesses and interviewing people, we don't want aspects of the investigation to be disclosed.
Ooh, if only there was a way to handle that. Oh, there is. Close it
enough, because I don't understand the, we expect hopefully the investigation to be concluded in the upcoming weeks, but we just don't understand the fervor or the desire for these records now.
Is your office doing the investigation?
No, there's a third-party investigator that
You were subpoenaed in February. So the fervor would be a discovery deadline in this case wherein they all have to get their depositions done.
How's that going to negatively impact the investigation?
Because we don't want recipient witnesses to be available of, internal correspondence and the materials we have regarding the investigation until we've had a chance to interview them.
So interview them.
The investigator. Not my office directly, but the town.
Well, so I don't know if you're going to know the answer to these questions, but how many people are left to be interviewed?
I'm not entirely sure.
Okay, but wouldn't you need a little more support for that argument to have some factual basis?
Yes.
That there are other people to be interviewed, and it's tough for me to just accept that blanket claim. What specific case or statute would you like me to look at to support the town's position?
We don't have one specifically, Your Honor. It was just more of just as a practical matter. The town just wanted.
I did not realize that counsel is coming into this hearing citing the newer statute. I will grant you, counsel, it is a newer statute, but you are coming to court to cite to the judge vibes. Vibes, Your Honor. What statute? Vibes.
All right, so let me ask Attorney Rosenberg. Your memo addresses the ongoing investigation. It addresses, talks about relevance, but it's a little light on scope and the overbroad argument.
Seems a little light on facts, Your Honor.
At first blush, when you take a look at it, it would appear to be, might be an argument of supporting the claim that it's overbroad.
Well, Your Honor, I actually think it's relatively narrow. It seeks basically two categories of documents. One, employment complaints.
This is now Reed's attorney speaking. He's in the upper top corner.
And basically the disciplinary record of a single town employee, Sergeant Sean Good, as well as communications to the extent the town has them. And I would anticipate the town saying they may not even have them.
So you want records about his employment, you want records about discipline, and you want communications between Sergeant Good and others. So tell me the nexus between the communications and the disciplinary category.
Well, so do you mean why are both of those relevant to the case? Is that what you're asking?
Yes.
Okay. Well, as Your Honor's aware, there was an investigation conducted into Mr. O'Keefe's death. That investigation led to Ms. Reed being charged and prosecuted. That investigation is at the core of the plaintiff's two main claims against Ms. Reed. One, it's all of the evidence, or nearly all of the evidence, that they rely on and will rely on in support of the wrongful death claim is the evidence gathered as part of that investigation. Two, they have intentional infliction of emotional distress claims that are based entirely on this idea that there was a, quote, false narrative about that investigation. Sergeant Good was one of the first participants and helped to begin that investigation. So to the extent there are records that indicate issues with Sergeant Good from a disciplinary standpoint,
we need it.
Those are relevant, particularly as that term is understood in the context of discovery. And I'll just share with the court to show this relevance. This morning, the plaintiffs took a deposition in this case of a third-party witness, and it was entirely based on this false narrative argument and the idea that what Ms. Reed has said about this investigation, of which Sergeant Good was one of the first officers involved, was, quote, false and caused harm to the plaintiffs. So I think to the extent there is evidence within his records that suggest issues with that investigation or would support Ms. Reed's prior statements about the investigation, or would bear on what evidence does and doesn't exist, how the evidence was gathered, how the evidence was preserved, etc. Those are all well within the bounds of discovery. And again, we're talking about a record of one employee. I struggle to see how that's particularly broad. If I was asking for all of the CPD records.
They didn't say it was too broad. They basically said, well, we can see how this might be discoverable and maybe public record, but just not yet. We just don't want to give it to you yet. Seemed to be their argument.
During a long period of time, I would understand, but I don't think there's a significant burden here. And I understood the town's objections really to be, both in their pleadings and in the conversations that counsel and I have had, to be this issue about the ongoing investigation, which simply, one is not a legally recognized objection to a subpoena in a civil case. But I also offered to counsel that we would consider confidentiality restrictions during the pendency of the investigation so that those concerns could be allayed, so that we could ensure that those documents would
Right.
only go to the parties, the typical restrictions in a confidentiality provision. Even though I don't think they have a legal argument, I was willing to consider that. The town hasn't proposed any. Instead, they just refused to produce based on this objection that has no basis in law.
You say in your opposition you're concerned about the request being overbroad, but it sounds like you haven't been willing to speak with Ms. Reed's attorneys about narrowing it.
Your Honor, that's not an accurate portrayal. We've had extensive conversations with Attorney Rosenberg regarding a barrage of requests. Actually, since the pendency of this motion, we actually got issued another subpoena and a draft motion to compel from Attorney Rosenberg, which the parties were able to, I believe, resolve without the intervention of the court.
Barrage is such a strong
Part of our
word.
frustration and our objection.
Part of their frustration is that you haven't turned over discovery. He's like, we've had a barrage. Well, if you turn it over, they'll stop asking.
Was, and Attorney Rosenberg, he keeps downplaying or obfuscating the subpoena. It's extremely broad. Our entire conversation with Attorney Rosenberg, we had multiple back and forth emails and communications seeking that he wanted that the scope was simply about the current investigation and investigation materials regarding Sergeant Good.
That's
the
not what
moment
you
we get the
said.
subpoena, however, it's this extremely broad request for a myriad of records completely unrelated to the current investigation. Defendant's counsel is seeking all records, communications regarding any town email record or communication regarding any discipline. So it's not just
So you are
physical
arguing that
copies
it's
of records of
overbroad.
discipline, which again, if that was simply the request, frankly, most of those would be a matter of public record anyways. We'd be amenable to produce those. But he's not asking for copies of records of discipline.
Well,
He's
why didn't you produce them? Why didn't you talk to them? I mean, frustration is not a valid reason for me to deny a motion to compel.
'Cause vibes, Your Honor. Also, this was not the town's initial argument in their oral argument today. It might be in their motion that it's overbroad, but the court brings it up and they're like, yeah, that too.
If you would produce certain things, why wouldn't you talk about what you would produce and try and narrow the areas of disagreement?
because it seemed clear that wasn't going to be productive, Your Honor. We've had a barrage of...
Well, tell you what, we're going to see whether it's productive. So I'm going to give you a chance to do what you're supposed to do under the rules. And while you're doing that, I'm going to ask you talk about this barrage of correspondence.
Talking. Go turn over discovery. Come back when you have another disagreement. All right, go get your shit done, everybody, is where the court ended that. Because remember, there are so many different issues going on in the Reed case. So that was a pretty quick hearing, all things considered. The parties and their lawyers were in court. So you've got the Waterfall, C.F. McCarthy's, the O'Keefe's, Karen Reed, and Canton. But the motion is between Karen Reed and Canton because they subpoenaed Canton back in February and Canton still hasn't turned over records. Though the attorney from Canton started their conversation with the court during this hearing from May 5th with, we agree that it's discoverable and it may be public record down the line, but we don't want to turn it over now because there's an ongoing IA investigation by an external third party into Sergeant Good. Why? Because of the text messages between Good and Proctor. Rosenberg laid out why it's relevant to them. Canton said, well, some of this might be overbroad after the court asked about it. And then the court said, no, if you agree a lot of this is discoverable, go turn it over and then come back to court with what you disagree with. And then they will be back in court on May 14th because the judge is now keeping them on short dates to make sure that this does not continue to roll month over month over month over month. Leonard, we're going to take a quick moment to talk about something that I love as much as talking about these cases with you, and that's the Leonard Shop and today's sponsor, Shopify. Because without Shopify, the Leonard Shop wouldn't have happened. From starting this shop in, the middle of the night at the speed of ADHD and building it myself, to growing it to where we're at now, bringing you another new launch that I am so excited to get into your hands. And one of the things I know that you love, that I love too, is the Shop Pay button. It makes it so easy to check out because you don't need to get out your wallet. You don't need to log in. It's all just handled and secure. Shopify makes it so easy to design your own site with their built-in studio. with hundreds and hundreds of ready-to-use templates, so your shop doesn't just look like everybody else's, but also it's really easy to get it up and running, and it matches you and your brand style. They have world-class expertise in inventory and international shipping, plus they can handle your returns, and if you ever get stuck, they have 24/7 customer service. Lawnard, it's time to see less carts go abandoned and more sales go with Shopify and their Shop Pay button. Sign up for your $1 per month trial today at shopify.com/lawnerd. That's shopify.com/lawnerd. Thank you, Shopify, for sponsoring this case brief. Now let's get back to it.
Now, this case has been pending for 619 days. And I acknowledge that for 231 of those days,
it was stayed.
Over 7 months, the case was subject to what was a very limited stay as to discovery involving Ms. Reed and depositions of certain of her family members. But that stay
was
expired
limited
over 10 months ago. When was it, in July? So coming up on a year. And I tried to figure out how a case that's been pending for so long could have so few depositions conducted. And one possible answer came when I was looking at the docket. Did you know that the parties are represented by a total of 22 lawyers in this case?
Holy shit.
Ms. Reed leads the pack with 10.
Holy shit. It's hurting cats. The judge is so mad. But the judge said the stay was not a stay of the entire case. It was a limited stay. What does that mean? It means that between the Waterfall, C.F. McCarthy's, and the O'Keefe parties, they could have all been moving forward doing things. Karen Reed didn't have to give discovery or be deposed or have depositions at that time of certain family members. But other things could have been done. And a stay doesn't stop Reed's civil attorney from participating in depositions of other parties. So the court's like, y'all didn't get to just wait. You, especially the other parties, could have been doing things. There are other parties.
Then I thought, well, maybe it's the issues in the case are so complex. But I think, as we all recognize, when you cut to the core of this case, it's a wrongful death
It's not
action
that complicated.
with a dram shop component
Yep.
and a claim of negligence in the operation of a motor vehicle. So it's really not that complex. And when I say that, I'm not trying to minimize the claim of the plaintiffs or the defenses of the defendants. So we're here for a status on discovery. So I'd like to hear from each party as to what depositions they have conducted.
Oh, boy.
Those that they have noticed and those that are intended.
On behalf of Waterfall, we have noticed some depositions that are scheduled for July because so many depositions had already been scheduled, but we have not taken any depositions yet.
Oh,
We
my
did
God.
Participate in the deposition that took place, I think, on Tuesday. In this case, we have depositions scheduled of a witness from one of the bars where Miss Reed was present, as well as the toxicologist for the Massachusetts State Police, Trooper Roberts, or I don't know if it's Trooper Roberts, Dr. Roberts, also scheduled in July.
That's it? Why couldn't you have done that a year ago?
We have ready to go today or tomorrow the deposition notices and subpoenas to two of the patrons of Waterfall. We've been coordinating with counsel for Waterfall, who also have an interest in those two witnesses, as well as with plaintiff's counsel. We also are going to notice the deposition of one of the patrons of our own bar. And then in addition to that, we've been in constant, or I should say frequent contact with plaintiff's counsel, Mr. Diller, as to the scheduling of 4 witnesses on behalf of C.F. McCarthy's, which are scheduled for May, June, and July, and we're working on dates that work for all the witnesses, Your Honor.
At this stage, plaintiff has taken the deposition of Stephen Scanlon. We've served 13 notices of deposition, 3 to occur in May. Karen Reed is noticed for June 19th. Aidan Carney is scheduled in July. We've got a pending motion to intervene in the Norfolk Superior Court to enforce our subpoena to enter into a protective order and get access to Mr. Carney's digital evidence. On February 11th, 2026, Your Honor, the defendant Reed noticed 19 depositions and scheduled them for specific dates. Plaintiff blocked off all of those dates and prepared for such depositions at that time.
Okay, Attorney Diller, let me, I'll give you the chance if you want to
he was
complain
ready to
about
roll.
something, but right now I just want.
He definitely wants to complain, Your Honor. You have read that tone correctly, but it looks like he's reading off of notes.
Attorney Rosenberg, on behalf of Ms. Reed.
Thank you, Your Honor. We've scheduled, we have noticed, I believe, a total of 15 or 16 depositions. We had, I believe, 2 that were supposed to go forward that witnesses were unavailable for, that we rescheduled. And we recently rescheduled some of the remaining depositions that we had previously noticed as a result of scheduling changes and the way that discovery has proceeded.
Someone answer for me, how many depositions have actually taken place since April?
The judge is so mad. Look at Diller. 1? The answer is going to be 1 depo? Oh, no.
April 9th.
1.
Okay.
Oh, boy.
Attorney Diller, I cut you off. You were about to convey some information or thoughts to me, so go ahead.
It sounded like Diller had a list of complaints, Your Honor.
On February 11th, Your Honor,
he went right back into his script.
Reed noticed 19 depots and scheduled them for specific dates. Plaintiff and all the parties blocked off all of those dates and prepared for those depots. So far, defendant Reed has canceled 17 depositions and renoticed all of them. For all of the depots that were scheduled to occur between March 24th and next week, Your Honor, the defendant Reed has canceled 13 depositions. Many of those cancellations occurred on the eve of those depots, at least as far as we were notified. Even though the defendant Reed had us block off all of these dates in February.
Did you make a motion for sanctions and fees then?
I've learned that since defendant Reed just sent off notices of deposition to the parties in this case, but did not bother to serve many of those deponents until the last minute. This clickbait lawyering is a tactic so that she can create a false narrative that these deponents are the ones who are canceling the depositions.
He is reading.
But because of the late cancellations, defendant Reed has now rebooked those 17 depositions.
Okay, but did you file a motion? Or did you really just want to say clickbait lawyering? Because it feels like you just wanted to say clickbait lawyering. Put it in a motion. If you think that it has legs, file your motion for attorney's fees and sanctions.
Can create a false narrative that these deponents are the ones who are canceling the depositions. But because of the late cancellations, defendant Reed has now rebooked those 17 depositions and without regard to other dates that we have already served depot notices for. Between now and August 1st, we have 35 depositions on the calendar in this case. Recently disclosed information from documents and depots may likely make necessary additional depots being noticed. Likely, I'm concerned, Your Honor, because I expect there will be third-party motion practice from some of these deponents. It appears that defendant Reed is using our case to conduct discovery for the 3 other cases that are currently pending with her involvement.
What?
So I just wanted to give you context.
There's going to be overlap, but it was Proctor that filed the motion in the federal case saying that he needed discovery for this case.
So I just wanted to give you context to the scheduling that has occurred up until today.
What do you want to do about it, though?
Your Honor, as you could expect, I'd like to respond to that context, please.
Diller's face. He won't even look up. And Rosenberg is like, is it my turn now?
Barking. Go right ahead.
Thank you, Your Honor. It's unclear if we're conducting a press conference here or a status conference in a civil proceeding. I don't know what clickbait lawyering is, but what I can tell you, Your Honor, is Attorney Diller has never raised any concern about any date of our depositions with us. If any party...
Oh, shit. You do not ambush each other in hearings like this. If this is a huge problem, you bring it up with the other lawyer, and by the time you cannot get it resolved, you file a motion and then bring it before the court.
If any party to this case has a concern with a date for a deposition that we've noticed, we are more than happy to discuss that. It is completely inappropriate for parties to come on to a proceeding like this and take the time to force us all to go back and forth about topics like this that should be addressed between counsel. So I would ask, Your Honor, that we not handle this in this type of proceeding. And instead, if there's a problem with scheduling, by all means.
If you got a problem, I solve it. Here's the thing. When you file a motion, you have to have a meet and confer, which means you have to give them a heads up. I don't think he wanted to do any of that.
Attorney Diller, have you spoken with any of the parties about these issues?
Yeah, I mean, quite honestly, many of these cancellations, we weren't notified until the eve. I'll have you know that.
But hang on.
That's not the question.
Did you call up any of Ms. Reed's 10 lawyers and say, hey, what's going on here?
The court's looking at Diller like, you're not Gen Z. You're not afraid of the phone. Pick up the phone, call somebody up, and ask them what's going on. No, you didn't want to pick up the phone and try to deal with it with the other attorneys. You wanted to just bring it to court and complain.
We've talked to them plenty, but we haven't talked about their position of canceling all these depositions, Your Honor.
Okay, well, it's kind of like you're trying to sandbag them, which isn't a great way to do it. Let's take a step back here and keep in mind that we all have to be professional in how we deal with these cases. And that necessarily involves communication. So let's try and keep that in mind as we go forward. All right? We'll see everyone on June 3rd.
We watched 2 discovery hearings in the Karen Reed case from May 5th and May 7th. We can clearly see that the judge's frustration level of why aren't we progressing forward is something that he is, I think, fairly gently but pointedly noting to all the parties. And the May 7th hearing started with the judge saying, why aren't we progressing? And I asked myself, why aren't they progressing? And then I said, well, self, there are 22 lawyers on this case. Is that part of the problem? No, they're all very experienced lawyers. They should be lawyering appropriately. So I said, self, is it that this is a really complex case? No, this is not a really complex case. I don't mean that in a disrespectful way, but no, the issues here are not unknown to us in the law. This is not a deeply complex legal case. Factually, a little bit different. So why, oh why, do we not have any depositions done? And then he went around the room. We're going to start with you. Why are no depositions done? Can we please explain around the room? Please explain to me why we're not done with the depositions. And then the court asks the most important question of all. How many depositions have been done? One deposition. So you can see that the judge is trying to get the lawyers to just move forward, because this case can't go to trial until discovery is done. And discovery has lingered and lingered and lingered. Not in a cranberries way. The court then stopped the attorney for the O'Keefes, Attorney Diller, as he was about to launch into another complaint, and finished asking about the depositions. Came back to Attorney Diller, who finished reading his monologue about the fact that the Reed parties have noticed depositions and they set aside the time, and then depositions got canceled and they got late notice. Yes, there are procedural methods to handle that. Yes, you can have a meet and confer and then file a motion for the late canceled depositions, which was not done. Attorney Rosenberg was like, I would love to respond to that, Your Honor. And this has never been brought up to us. And so the court turns around back to Attorney Diller and is like, hey. Well, I do have to say, Attorney Diller, it seemed, wanted to get his line in of this is clickbait lawyering, to which Attorney Rosenberg responded on the spot, not with a written out monologue, saying, Your Honor, is this a press conference or a status conference? It's unclear what we're doing here. And the court shifted back to Diller saying, have you talked to the other parties? Diller's face went through every emotion in the world and landed on, we've talked, Your Honor, but not about this. And the court said, I think you are sandbagging. You're ambushing, essentially, the other side by bringing this up in court, but not filing a motion and not talking to them about it before court. That's not how things are done. And then admonished, I mean, the way the entire class gets made to run, but admonished Diller that this is not the way we do things. This is not professional. And we need everybody to work professionally and together, which means you need to talk to the other attorneys. This doesn't shock me after we've gotten to the point that Diller was forced to destroy Karen Reed's, reply all email. Because when the attorneys reached out to Diller and were like, hey, that email wasn't meant for you. It's clear it wasn't meant for you. It was like 40 minutes ago. Can you just delete it? And Diller was like, no, I'm not deleting it. And then they had to go through an entire motion practice to get the court to come back around to delete it. Delete the email. We have a sealed copy for the court record. So I'm not surprised that this is what's going on. But the court clocked it immediately. And from my perspective, it does not help your case and your clients if you persist in aggravating the judge. There are times where aggravating the judge is what you have to do to represent your client. And there are times where the judge isn't going to love it and you have to just do what's right for your case. We are not watching that happen here. That's not this moment. This is, to me, seemingly needless. And if Diller wanted the headlines to be clickbait lawyering, I imagine he was real disappointed, because I would guess at least some of them are going to be, the court says that Diller is sandbagging. Not Diller says Karen Reed's lawyers are doing whatever clickbait lawyering is. Stop trying to get a headline and just get your case done. It doesn't help anybody. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.